This is one of the propaganda they put. They say Mazi Nnamdi Kanu refused to defend himself. It is not that Mazi Nnamdi Kanu refused to defend himself, but they intentionally muzzled Mazi Nnamdi Kanu and make sure he did defend himself. Look at another one. Let's read this one too. This one is another important one. The fell consequence of ejecting Mazi Nnamdi Kanu from the courtroom. The fell consequences of ejecting Mazi Nnamdi Kanu from the courtroom. These were what transpired, and people were asking questions on this while. And I thank God that Barrister Aloy Ejimako have found time to elaborate on this as the appeal is coming forward. In the theater of criminal jurisprudence, there exists a thin, unyielding line between the preservation of courtroom decorum and the outright annihilation of defendants' fundamental rights to a fair trial. When a trial involves capital offenses, that line becomes an absolute iron wall. When Justice Omotosho on 20th November 2025 ejected Mazi Nnamdi Kanu from the courtroom, he may have believed he was stamping his authority on a volatile proceeding. However, by continuing the proceedings in Kanu's forced absence, especially while the defendant had openly expressed his lack of confidence in the court, and while no counsel was presented to bridge the gap, the land trial judge committed an egregious constitutional error. The bedrock of Nigerian criminal justice is Section 36, 6C of the Constitution, which mandates that every person charged with a criminal offense is entitled to a defense, to defend himself in person or by legal practitioner of his own choice. While statutory provisions like the Administration of Criminal Justice Act provide narrow windows for a trial to proceed when a defendant purposefully absconds, the rule radically shifts when a defendant is forcibly excluded by the court itself. The fatal error here lies in continuing high-stake terrorism and capital offenses trial with an empty dock and an empty defense bench. The Supreme Court of Nigeria held in Adeoye versus State 1999 that it is a fundamental principle of our criminal jurisprudence that a trial for a capital offense or serious felony must be conducted in the presence of the accused persons. This is their law. But when it comes to Mazi Nnamdi Kanu case, every single law of Nigeria was thrown to the dustbin. Keep in mind that Mazi Nnamdi Kanu was not just absent, he was sent out of the court. And to compound the gravity of the ejection, Mazi Nnamdi Kanu had no legal counsel present to defend his interests during the forced ejection. Under Nigerian law, a trial judge cannot comfortably lock a defendant out of the room and simultaneously look past the total absence of the defense team to stand in for the defendant. In Galadima versus the State 2012, the Apex Court emphasized that where an accused person is unrepresented by counsel in a serious criminal trial, especially one touching on capital punishment or severe felony, any proceeding conducted in his absence without the aid of legal representation is nullity. This is Nigerian law. What I read now is Nigerian law. But you can never see people explaining this in their conventional media. They have already succeeded in creating their own narrative. And I thank you as Aloy Ejimako is bringing these things forward. for people to know that Nigerian law stated different from what they are doing against Mazi Nnamdi. The illegality on the case of Mazi Nnamdi Kanu is overwhelming. I don't even know how to look at it. Look at this. A case that has been settled in Nigeria, Galadima versus the state, 2012. The Apex Court emphasized that where an accused person is unrepresented by the counsel in a serious criminal trial, especially one touching on capital punishment or severe felony, any proceeding conducted in his absence and without the aid of legal representation is a nullity. And some of you are still afraid. Oh, they want the death penalty for Mazi Nnamdi Kanu. They want this nonsense for Mazi Nnamdi Kanu. By forging ahead without Kanu and without a counsel for him, the court effectively turned an adversarial criminal trial into an ex parte proceedings. What makes Justice Omotosho insist on proceeding even more untenable is the explicit lack of confidence in him by Kanu prior to the ejection. Already, Kanu, Mazi Nnamdi Kanu, as supreme leader, has no confidence on him. He doesn't even have right to preside over. He doesn't even have the jurisdiction to speak on that case anymore. When a defendant forcefully raises a reasonable apprehension of bias, the judge's primary duty is not to push forward to prove his stoicism. It is to take a pause. The Supreme Court in the Dumas versus Okorodudu 1976 held that a judge must be indifferent to the parties and should completely insulate himself from the heart of the battle. But of course, you know that at a point in time, this, what do they call him? This man, what do they call him? Became part of the, not even at the time, he have always been part of the government. He was even speaking for the prosecuting counsel. He was making a case for the prosecuting counsel. The prosecuting counsel didn't even have time to speak. Instead of resorting to an adjournment to allow tempers to cool, the judge overreacted by expelling the very man crying foul and then continue with his proceedings. To the reasonable observer, the optics are damning. A judge clearing the room of a so-called unruly defendant, then quietly wrapping up the case in the dark. Courtroom misconduct, perceived or real. Courtroom misconduct, perceived or real, by a defendant can be frustrating. And judges are human beings, prone to exasperation. But the law provides tools to manage such situations, none of which includes conducting a capital trial while the defendant is locked in a holding cell. His defense table is completely bare. That is not part of it. Thus, Justice Omotosho's decision to continue the proceeding under this precise condition was perverse and represents a total collapse of due process that will surely shock the conscience of the appellate court. This is a beautiful piece that was written by Aloy Ejimako. And this is not written for the Zoological Republic government because they will do what they want to do. But it's interesting that he's putting it forward for men of conscience and for the world to be seeing it, be going through it, and know what really transpired. It is very important. Very, very important. So I saw this and I felt it is important that we bring it out, read it together, because so many of us have been worried about these questions and these answers that follows it. Why this and why that and why this and why that? This is another one. How Mazi Nnamdi Kanu's self-representation flawed his conviction. This is another one on the case of Mazi Nnamdi Kanu. How Mazi Nnamdi Kanu self-representation flawed his conviction. This is one of the propaganda that the enemies of Mazi Nnamdi Kanu are carrying out. Those idiotic people that have been paid to blackmail Mazi Nnamdi Kanu, more especially the one they call Nega Chimezi. That it was because Mazi Nnamdi Kanu represented himself, that is why he was jailed. That because Mazi Nnamdi Kanu represented himself, that is why he was given a life sentence. And that is because of this. And these are people that don't have the knowledge of law. I want us to read this together because this is also one of the popularly asked questions for people to understand what really transpired. So, Barrister Aloy Ejimako also explained here. He said, how Mazi Nnamdi Kanu's self-representation flawed his conviction by Aloy Ejimako. Following the debriefing of his legal team, led by Chief Kanu Agabi, San Mazi Nnamdi Kanu firmly announced his intention to personally handle his own defense. The trial court accepted this waiver of counsel, asked if he wanted an assigned lawyer, noted his rejection, and then proceeded. Now that the case lies on appeal, the deeper central question the Court of Appeal must confront is this: can a defendant facing charges that carry the death penalty legally waive his right to counsel under Nigerian law? The short answer is no. I want you to pay attention. This is interesting because this is one of the questions that is in everybody's mind. And when Aloy Ejimako answers these questions, it is very important. That is why all the lovers of freedom that are following the case of Mazi Nnamdi Kanu must pay attention. And make sure you like and share this program so that others can be acquainted with what is going on. So I want to read it again from the beginning. Following the debriefing of his legal team, led by Chief Kanu Agabi, Senior Advocate of Nigeria, Mazi Nnamdi Kanu firmly announced his intention to personally handle his own defense. The trial court accepted this waiver of counsel, asked if he wanted an assigned lawyer, noted his rejection because he rejected. He said no, and they noted his rejection, and then proceeded. Now that the case lies on appeal, the deeper central question the Court of Appeal must confront is this: can a defendant facing charges that carry the death penalty legally waive his right to counsel under Nigerian law? And the barrister went further to answer. He said, the short answer is no. In allowing Mazi Nnamdi Kanu to represent himself in a trial involving capital offenses, the learned trial judge unarguably committed a fatal fundamental error in law. Under the Nigerian criminal justice system, the right to legal representation in capital offenses is not a luxury. The defendant can decline. It is a rigid and mandatory constitutional safeguard that the court has an absolute duty to enforce. even against the explicit wishes of the defendant. I hope you understand that part. At first glance, there exists an illusion of permissible self-representation that lies in section 36, 6C of the Constitution, which appears to sanction self-representation by stating that every person charged with a criminal offense is entitled to defend himself in person or by legal practitioner of his own choice. That may be in misunderstanding or less severe felony, where the choice to speak for oneself is a permitted prerogative. However, the Constitution does not operate in a vacuum. It is echoed on the ultimate pillar of fair hearing, and contemporary Nigerian criminal jurisprudence has long recognized that the gravity of capital offenses, where human life hangs in the balance, strips away the court's discretion to permit self-representation. The statutory directive is enacted under the Administration of Criminal Justice Act, which explicitly curtail the right to self-representation when the stakes are grave. Section 267(2) of the ACIA leaves no wiggle room for ambiguity when it provides that where a defendant is charged with a capital offense or an offense punishable with life imprisonment and he is not represented by a legal practitioner, the court shall appoint a legal practitioner for his defense. The operative word utilized in the above provision is shall. In statutory interpretation, it is an established canon that shall denotes a command. It imposes a mandatory duty, leaving zero room for judicial discretion or defendant's personal whims. What you are seeing is in the loopholes. These are things you're going to see as we head into the appeal. This is expectation for those of you who are worried and shouting and talking and blabbing and saying what you do not know. And I thank Chukwu Okukabema that Allah Ejimako had time to answer these questions. Thus, when Kanu's legal team stepped aside, Justice Omotosho's question should not have been, do you want me to assign a lawyer to you? Instead, the judge should have immediately made an unyielding decision to appoint a lawyer for him. Why? Because Kanu's refusal of counsel is invalid as a matter of law, pure and simple. The Supreme Court has repeatedly held that the presence of counsel in capital trial is a condition precedent to the validity of the trial. In Josiah v. State, 1985, the Appellate Court held that in capital offenses, a defendant must be represented by counsel at all stages of the trial. This was reaffirmed forcefully in Ganiyu v. State, 2013, when the Supreme Court made it abundantly clear that a trial conducted for a capital offense without legal representation is nullity, as its absence completely robbed the trial court of the jurisdiction, of its jurisdiction. Granted that Justice Omotosho may have felt justified in forging ahead, giving Kanu's articulated disposition. Yet, as a matter of law, lay competence is not a substitute for counsel. A capital trial involves intricate rules of evidence, procedures, and navigation of highly complex constitutional and statutory framework, unique to capital offenses trial. So, by permitting Kanu to navigate this labyrinth alone, the court allows a fundamental constitutional infraction that may very well void the entire outcome of the trial. I hope you understand. For those of you that have doubt, for those of us that are worried, this response that is coming from my lawyer Jumafko is amazing, and it is very, very important. That is why I felt I should go into it and read it for Biafrans to see. Because so many lies have been told about this Mazi Nnamdi Kanu, self-representation, and so many things have been told about it. So many people have said so many things in it and all that. But when you go through these responses that was given by the lawyer of Mazi Nnamdi Kanu, it will help you to understand better. It will help you to understand better. That is why I feel I will bring it for us to look at. So the strength of any democracy is often measured not by how it treats those who agree with the government, but how it treats those who disagree with it. That is why discussions surrounding detention of our supreme leader Mazi Nnamdi Kanu, the trial, the legal proceeding involving our supreme leader, continue to attract both domestic and international attention. Now you understand why Nigeria is shaking, why they are scared. The case of Mazi Nnamdi Kanu raises broader questions about civil liberty, freedom of expression, political dissent, and the right of individuals advocating controversial political positions. Human rights organizations around the world have consistently emphasized that the importance of due process, transparency, and adherence to legal standards in all judicial matters, very important. This principle should apply equally to every citizen, regardless their status, ethnicity, religion, political opinion. Everybody must be treated equal legally when it comes to legal issues. That's the right thing to happen. The reason international attention matters is not because foreign governments should dictate the future of the Zoological Republic of Nigeria. No. Rather, international engagement can encourage adherence to universal recognized human rights principles and legal norms. And that is why we are calling on the United Nations, calling on the United States. And that is why I appreciate you, Kabiama, for what Arnold is doing. Some of you don't know the effect of what Mike Arnold is doing. Arnold is a very strong force. That is why every one of us must continue to support him. Any way we can, we must continue to support him. A man that has devoted his time to speak for the truth. Not because he was paid. Not because he was bought over. History has shown that international observation often contributes to greater accountability, transparency, and respect for human dignity. You see, when we talk about internet, that is why we are calling for international intervention, even in the case of Mazi Simon Ekpa. The case of Mazi Simon, when we are talking about, the reason I personally support the international lawyer is that he needs an international intervention. The case of Mazi Nnamdi Kanu is just the same like the case of Mazi Nnamdi. The only difference is that Mazi Nnamdi is in a civilized world, unlike Mazi Nnamdi Kanu is in a third world country. But in that same civilized world, the only difference, they are very smart in playing their own human rights abuse, not like they did in the case of Mazi Nnamdi. In the case of Mazi Nnamdi, his right was also abused. Mazi Nnamdi was not allowed to present evidence against Nigerian government in the court. The prosecutor rejected every single evidence that was presented by Mazi Nnamdi. The lawyer could not tender any evidence to the prosecutor. And you thought that is right? You think that is right? You think it's a mistake? It was calculated and intentional. His right was totally taken away from him. And they were able to do that because there was no international intervention. It was Finland against Mazi Nnamdi, standing alone in the court. The court that were defending, the lawyers that were defending him are lawyers of Finnish lawyers. Finnish lawyers working with Finland. We need an international lawyer who is going to work from the outside, not in the courtroom. Mazi Nnamdi needs international lawyer that is going to work from the outside, not from the courtroom. Reach out to the United Nations, reach out to the Foreign Affairs Minister of Finland, reach out to the European Union and the United States more especially, to call the attention of Finland that they are watching, they are observing. And that will make Finland to think twice each time they want to abuse his right. Because there is no reason not to admit the evidence against Nigeria, no matter how horrible it is, no matter how simple or how difficult it is. One of the reasons I heard he was given that the images were so horrifying that he couldn't be able to lay eyes on it. So because of that, you will not take his evidence. Because of that, you refuse to take his evidence because what you saw was so horrible. Is that enough reason? Is that enough reason? That the videos you saw are so horrific that you can't stand it. They were able to play that game because there was no international representation. You see why every one of us have to sit up. These two cases of our leaders, Mazi Nnamdi Kanu and our Prime Minister Mazi Nnamdi, are similar. The only two different issues is that one is in the Western world and one is in the Third world. In case of Nigeria, they do their dirty deal. They can do anything and get away with it, and they are not a lawless place. It's a lawless place where the rule of law does not work. But in case of Finland, they are always manipulative and more calculative on how to take their steps. And that was why you see, even as we speak today, when you see the sentence that was given to Mazi Nnamdi, you know that his case has nothing to do with terrorism. When you look at the 6-year sentence that was given to Mazi Nnamdi, that should let you know that the case of Mazi Nnamdi has nothing to do with terrorism. But somehow, Finland were compelled to make sure they hold him down. The case of Mazi Nnamdi, look at it, life sentence. These are two similar cases. One life sentence, one 6 years. International intervention is very important. International engagements can encourage adherence to universally recognized human rights principles and legal norms. This is why we don't stop. Any place you are, do not stop paying attention to international intervention. That is why we appreciate our beloved brother, Mazi Mike Arnold. Let those who want to go and cry, cry. Those who want to go and die, die. We recognize it. History has shown that international observations often contribute to greater accountability, transparency, and respect for human dignity. That is why it is important. We need international intervention by all means necessary. Around the world, many countries cooperate through diplomatic channels, international institutions, and human rights frameworks to address concerns relating to security, justice, and governance. Constructive international engagement does not mean interference. Just like when we call the United States of America, come and help, we are calling on Donald Trump. What Donald Trump is doing or what is going to be coming to do is not interference. What we are calling him on all this while is dialogue. It means cooperation. It means encouraging peaceful solution. It means supporting institutions that protect human rights and the rule of law. The challenges facing Nigeria cannot be solved through violence. What is going on in Nigeria today cannot be solved through violence, but through sincere and truthful means. Peaceful dialogue, referendum for people to make their decisions, not by bullets. The challenges facing Nigeria cannot be solved through violence. They cannot be solved through hatred. That you hate Mazi Nnamdi Kanu, you hate the Igbos, you want them to die. It cannot stop your problem. It cannot solve your problem. They cannot be solved. Through ethnic divisions, they cannot be solved. Through intimidation. Lasting solution requires justice. Number one. You must have to start from giving justice to those who want justice. Mazi Nnamdi Kanu have no business being in any jail. He has no business being in any prison in any part of the world. Likewise, Mazi Samuel has no business being in jail. Lasting solution requires trust. Lasting solution requires accountability. Lasting solution requires sincere leadership. One of the greatest changes, one of the greatest danger facing any society is when citizens lost confidence in institutions. Like you see in the Zoological Republic. Even those who are preaching and claiming one Nigeria do not trust the Nigeria they preach. They don't trust it. None of those people talking about one Nigeria trust it. They don't. Not even the president himself. Nobody is ready to put their life on the line for that contraption called Nigeria. When people begin to feel that their concerns are not being heard, frustration increases. When frustration increases, tension rises. When tension rises, stability becomes more difficult to maintain. That is what the situation of the Zoological Republic is today. This is why government everywhere must remain committed to listening to citizens, protect the right and ensuring equal treatment under the law. Equal treatment under the law. To the international community. Many observers continue to call for close monitoring of development relating to security, human rights, and political freedom in Nigeria. The objective should always be peace. And that's what the objective is always peace. The objective should always be justice. The objective should always be protection of innocent lives. The objective should always be strengthening of democratic institutions. Even though that is not what we see in the Zoological Republic of Nigeria. That's not what we see. The objectives of the United Kingdom and France is not to protect life and properties. None of them is interested in how terrorized the citizens are. The only people that are paying attention to what is happening in Nigeria in terms of insecurity today is the United States of America under Donald Trump. No other people is interested. The French are not interested. The UK is not interested. The Chinese are not interested. Only the United States. to young people watching this broadcast today, I want to say this. Every young person that is watching this broadcast and those who are going to watch later, wherever you're watching, either you are watching on TikTok, on YouTube, on Facebook, I want to say this. Never allow frustration to push you towards violence. Violence often creates more suffering. That we all know. Violence often destroys the very community it claims to defend. Instead, remain committed to lawful engagement, civic participation, education, advocacy, and constructive dialogue. And I bet you this is the path that the IPOB have taken for a very long time, both under Mazi Nnamdi Kanu and under Mazi Nnamdi Kanu.